everyone, and welcome for our final session of Alt Legal Connect. We are in high demand, crafting effective and creative demand letters. In case you haven't met me for the rest of the entire conference, I'm still Bri Mantel. I'm still your Director of Education. I'm still the Master of Ceremonies for Alt Legal Connect for another like 2 hours or something, a little longer than that. And I'm still here to make sure that you have a fantastic time. So let me know how I can do that. If you do have any feedback for us, please, please, please provide that in the feedback form. We definitely care about what you have to say. We want to learn from it. Um, so provide us that there. Um, and you haven't been a jerk for the entire rest of the conference. Let's keep that up for another, I don't know, 2 hours or so. And then you can, be a jerk if you want to, but I don't think you will be. I don't think any of you are jerks. But all right, please note that we are offering CLE credit for this session through the state of California. However, you must be in the session. You must attend it live in order to qualify. The session will be 70, that is 70 minutes long. I need you to be here the entire time. I need you to write down the code when I give it to you. Don't try to memorize it. There won't be any spaces in it. It's just going to be a number, a word, and another number, in case that helps you any. We will send a survey at the end of the session. Please make sure to put the code in there and submit the survey. Alt Legal, still not a law firm, so we're not giving you any legal advice. Moish is probably also not giving you any legal advice, but also the views that he expresses are his views. They might be ours too, but I can't speak to that. I can just tell you that he has his own views. If you have any questions for Moish, make sure to put them in the chat and use the word question in front of them so that we can get those over to him. So I am pleased to welcome our final speaker, our final session speaker of All Legal Connect, Moish Peltz. Moish is the IP chair of Falcon Rappaport and Berkman. He has a knack for technology and works to help entrepreneurs, including tech companies, protect their trademarks. Recently, Moish has been touring the internets to tell all the world about the joys of NFTs. If you want to see the recording of his webinar about that, we'll put a link to that in the chat in just a few minutes. So thank you so very much, Moish. We are super excited to hear you talk, and it's all you.
Okay, great. Well, thank you, Bree, and thank you everyone from the Alt Legal team, Nahal, Saren, Stacy, Sophia, everyone else on the team for welcoming me here to speak today, and also for just being a great partner over and over again. And you mentioned the NFT presentation I did earlier in the year, which I thought was fascinating. It was really fun to do with Alt Legal, and then all the announcements that we've heard this week about the new product. We're just really excited and love working with you guys. So thank you. With that said, Bree mentioned I'm the chair of the intellectual property practice group at Falcon Rappaport and Berkman. Work on a lot of high tech issues, a lot of cryptocurrency, emerging tech matters. Also co-chair of our emerging tech department and working on NFT matters. And a lot of these demand letter questions, right, are even more I think relevant and prominent in what happens next, because a lot of these issues are resolved informally through negotiation, through it may be advantageous to do that even, right, compared to, well, it's never been litigated before. There are new issues, there's new trademark issues, there's new everything that comes up. So one, I think we have a really important role as attorneys in that process of understanding, the pre-litigation process, of advising clients what the different options are, and thinking strategically about how that plays into the client's business goals. Of I don't think anyone's in the business of getting into litigation unnecessarily. It's all structured around what are the client needs and how do we get there. And I think using effective and creative demand letters, the topic of today's presentation, is a really important part of that. And it also allows us as attorneys and this being the last session before we get out and get to either further networking or back to our ordinary lives, is a fun outlet for us creatively and expressively to both engage with the client and to draft interesting demand letters. So that's the idea here today, is to run through some of these creative ideas. So again, as we mentioned, it's not legal advice. Let's continue going. So today, I'm going to through a couple of different examples of either really good or really uncomfortable, perhaps not well thought out demand letters, to try and dissect some of these and to show what I think makes them effective or ineffective, all with what I mentioned before of getting into what is the overarching client goal. Is it to literally make someone cease and desist, or is there some larger goal of which that demand letter is just one facet of? Next step would be due diligence, right? So from a factual and legal perspective, thinking through what should or should not be in that demand letter, and what other investigative steps you might want to take. Actually writing the demand letter itself, and throughout there'll be some creative examples sprinkled in. By creative examples, I mean just other demand letters that have been newsworthy or something else. And then lastly, pitfalls in terms of some feedback that people have gotten negatively from demand letters that weren't well thought out. So starting at the top here, getting back to the strategic question, why do we send demand letters? So, and there's a question here about, non-litigators versus litigators sending demand letter. I think that's a really important question. I know it's something I've anecdotally been speaking a lot about with other IP practitioners that may, perhaps they're mostly doing trademark prosecution. They don't really do any litigation, but they do offer, either demand letters as a service, like here's a form demand letter you can use as part of a prosecution package, or they do the work, but they don't actually do the litigation. And so I think, it's something that everyone should be thinking about of, well, if we're identifying the litigation goal, at what point in the process is it appropriate to say, this is a potentially bet the business issue, right? This is a strategically important question for the business. And, here's a form demand letter, let's just send it. Is that consistent with the goal of the business, or is, the issue something that is more strategic, that really you should be thinking about with a more litigation oriented mindset, right? Because the first demand letter that you're going to send out is often very crucial in a litigation that, I've been involved in litigations that take 5 or 6 years to resolve. So, and for example, one of those litigations, we got attorney's fees because we said in the first demand letter on day one, like, this is the facts and law of the case, and this is how it's going to go. And if you don't comply with what we're saying, then here's what's going to happen. And the court, 6 years later says, that's exactly what happened. We're going to give you fees because, so there is a lot of advantage, I think. And it's obviously, we'll get into this a little bit more, but every circumstance is different. And some people just want a form demand letter, and that's what they need, and that's what they can afford, and that's what we're going to, help them get the best version that we can get. But some people might need something else than that. So I think that first bullet point here is identify the goal holistically of what that company needs. Is it the most efficient demand letter just to preserve their right or some other concern of theirs, or is it something else? And so I think it's going to be a case-by-case basis about evaluating that in a client-centric manner of what the right outcome is for this client and how this fits into a larger strategy or does not. But I think no matter how basic a demand letter is, I think there's some things that need to happen, and I think it may happen at the attorney level, and maybe something where it's happening, more on the client level of researching the facts, right, documenting those, researching the law, ultimately writing, sending that demand letter, and then using that demand letter as a tool to resolve that dispute somehow, or using the demand letter as the first step in some larger litigation process. So here I have a demand letter, and this is probably relatively small on your screen, which I would like to dissect a little bit, just because I think there's certain elements of every demand letter that seem kind of basic, but let's at least talk them through. Right? You have the sending party, attorney, date, address, certified receipt requested. So this actually seems like a pretty good demand letter, right? There's a subject line. I don't know if you can tell what this is about, but it's this attorney, law office of Downing, said he's representing himself in the matter, and he went to a restaurant, ordered the Saturday special, which normally includes an entree, 2 sides, and crucially, very crucially here, a soup. However, when he made his order, he was told by the server that they were out of soup. So he asked the server for a discount, or another side, or some other thing. However, the manager came over to tell him that, sorry, we can't give you the soup, that it's a flat fee kind of thing, right? So unfortunately, this letter, this situation led this attorney to, he felt misled. He felt slighted by this. He felt that when he had ordered off the menu that was a contract, that was acceptance of an offer by ordering that, and created a binding contract, which was legally enforceable. And so, and as a result, he sent this demand letter, right? So this is, in my mind, like it's actually a pretty well-written demand letter. I hereby demand that you pay $2.25 in damages and another $250 in attorney's fees for the cost of this demand letter, and you change your policy, right? So there's a monetary and sort of a almost like injunctive kind of relief sought here, right? We want you to change the policy, and if we have not heard from you in 10 days, I will file my lawsuit against you, right? It's also pretty good, right? Because he's saying, if you do not do this, I will do that, right? There's stakes to this demand letter. However, I think we all can recognize that even a well-written demand letter that is put together intelligently, that has all the right elements of what would normally be a pretty good form, does not fit into some larger, strategic motive, right? So that this attorney may have been, and obviously the reason we're talking about this particular demand letter is because this attorney sent this demand letter in real life, and it went viral and got significant feedback, ridicule, that kind of thing. So I would suggest that, and hopefully he's not on here. If he is, then it'd be a nice conversation. We can perhaps bring him up on stage. But I think everyone here, you should be thinking in the back of your head, what is the strategic goal of this demand letter? And if I send this demand letter, what is the potential response? So I think the idea here is that you can create a really good demand letter, and it can have all the right elements of a really good demand letter. However, it needs to fit into the overall legal goal and the purpose of sending that demand letter. So my first job was with an attorney, Stephen Peretz, well-known intellectual property attorney down in Miami, Florida, and he would say this to me almost every day: think strategically, act tactically, right? Let's take a step back, identify the goal. What is the goal of what we're doing here? And then how does this demand letter or something else operationally act tactically in furtherance of that overall strategy? And so the demand letter is just one of the many tools in an IP practitioner's tool belt, and can be pulled out when it's needed. But I think we need to also be thinking strategically that when we're pulling it out, what is the goal, and is that goal achievable through a legal process, right? So when you don't get your soup, you maybe just talk to the manager. If you don't get the manager's attention, maybe you write a bad Google review, but it's perhaps not the right time for a demand letter. And then as you're identifying this goal, what are the facts and legal support there, and is the demand letter itself even the right option, right? Is the attorney the right person to send a demand letter? Should perhaps one of the principals of the business either reach out directly to the person that's slighted, right? Maybe you talk to the manager, right? Or is the attorney the right option? So you should be thinking, someone's coming to me with an issue. As an attorney, my role isn't just to give him a demand letter and send him on his way. It's to be thinking about what is the right way for this business to approach this dispute and to advise the client accordingly and work with them to get in strategically that to resolve that goal. So here we have a different demand letter that I think is basically on the opposite end of the spectrum, right? Here we have on the left side, you see the famous Jack Daniel's Tennessee whiskey logo, right? On the right side, you see a book which obviously is mimicking that famous design, Broken Piano for President by Patrick Wensing. And so this person created this book, and ordinarily a big brand like Jack Daniel's would say, here's the form demand letter, cease and desist, like please stop, and maybe you owe some damages or should at least get rid of these books. But that's not what they did, right? It wasn't from a big law firm. It was from Jack Daniel's inside counsel, trademark department, right? And it's again going to be a little small. I'm sorry that we're kind of looking at these demand letters. I don't know if there's a better way to present them than what I have here, but I'll just blow up this part of it, right? Instead of saying cease and desist and get out of here, they said, in order to resolve this matter, because you are both a Louisville neighbor and a fan of the brand, we simply request that you change the cover design when the book is reprinted. If you'd be willing to do that sooner rather than later, we'll even throw in some reasonable costs to. So I think the point here, right, is Jack Daniel's or anyone doesn't need to be in the business of just crushing down little people that love your brand, or that's not really necessarily. I mean, different brands feel differently about this, obviously, and there's definitely room for disagreement, and it would fit into a larger cease and desist strategy. But the idea being, people love your brand and they're mimicking it in a affectionate way. Perhaps that isn't someone that we should be just in a rote manner crushing down. Maybe we should be giving consideration to. This is someone in Louisville. He loves the brand and he's making an homage. And ultimately, that's not aligned with our trademark goals. But there's a better way to approach that dispute rather than at least immediately jumping to that cease and desist result. And so here, Jack Daniel's actually got the opposite reaction, right? This demand letter went viral for all the good reasons. People are like, wow, that's actually a very nice way to do it. And ultimately, I believe they achieved the goal here of, the next time the book was printed, the cover design was modified and Jack Daniel's protected their trademark and preserved their trademark rights and other IP rights, and everyone went on their merry way without contested litigation. So getting into factual due diligence, I think, again, going back to why we're sending these demand letters, I think it's very important, and our role as an attorney is to use the demand letter as an opportunity, right? So both you with the client, right? So depending on whether you're someone that's going to be litigating this matter, perhaps you're, as the question came in earlier, you're looking to refer it out. Either way, a client's coming to you and they have an issue, and this is an opportunity for you to understand their business, their issue. If you're going to be sending the demand letter and doing the litigation, then you could do this. You probably should, if you're doing this demand letter, is do some thorough due diligence. Now, obviously, every client's different. They could have everything from, they emailing you the facts or summarizing them to you, and then you're just translating that into a demand letter. Perhaps it's a situation that is a really important or perhaps a really potentially risky situation for the client. Perhaps you're thinking this may ultimately end up in litigation. So I think obviously working within the different cost boundaries here, right? These allegations should be essentially independently investigated by you. You should be looking at the facts as they come up to say, what are the facts as they come up that should go into the demand letter? Do we need to review documents? Do we need to go on websites? Do we need to hire? I know there's sponsors of the conference that do thorough outside investigations. Do we need to hire someone like that to go out into the field to test buys, to look for counterfeiting, things like that, right? So what sort of real world investigative steps Do we have to have a conversation with the client? Do we have to take statements from employees? Do we have, what do we need to do in order to properly investigate, document the issue, and prepare that ultimately for litigation, right? So if our fun, goofy demand letter does not resolve this, even if that's your goal, it's like, hey, let's try and resolve this amicably in a fun, sweet way, or just with a vanilla demand letter if you don't want to be cute about it, right? We hope we resolve it amicably. We hope we resolve it without litigation. But as a litigation kind of hat on, you should be thinking, if that does not work out, do we have all the evidence we need preserved so that it can be used, it can be introduced as evidence in litigation? Because ultimately, if your efforts do not pan out, that's where this might be trending, right? So that's something you should be thinking about. Again, aligned with the goals of the client here, strategically, is this something where that is an outcome? If that's an outcome, what do we need to do to make sure that we preserve our rights in litigation going forward? As part of that last bullet here, right, is the intellectual property properly protected, right? So even if you are someone that's just going to be referring all this work out, do any litigation, it's okay. Here's someone that you're referring the matter out to, or you even as a client, you don't want to spend time and effort to do a whole pre-litigation investigation. However, at the very least, as part of our demand letter strategy, do we have all the intellectual property in place? Are we protected? Perhaps this raises new risks you've never thought about. What sort of applications or registrations do we have, or do we need to get in place? Do we need to consider new filing? Should we be looking at different territories? Someone spoke early in the conference about international issues. Thinking through as we're doing this factual due diligence, geographically, where are things located? Do we need to hire counsel in those jurisdictions to help us analyze and think through consequences that may relate to that jurisdiction? So kind of diving a little bit deeper here into the factual elements of demand letters, identifying the proper parties, recipients, are there entities, individuals who should be getting this letter, who should be named in the letter as a recipient? Is this someone that you're in a contract with, or you've had some prior existing either dispute or relationship with where you know who that person is, or you don't, right? And then the next bullet, requesting and reviewing relevant documents. So clients will often say, here's the dispute, here's what you need to write a demand letter, and then you just start doing it. Oftentimes it's worth that phone call to discuss the dispute with them, to understand whether that's really the world of documents that are going to be involved in a potential letter writing campaign, whether there's other things that might be involved, whether there's people that you need to speak to both inside the organization or externally. We mentioned kind of gathering witness statements, things like that, right? Are depending again on the how significant the dispute is and the different costs that may be involved there. Next bullet point: ensure compliance with contracts, right? So if you have a contract with that party, is there an existing contract? Is there just a handshake agreement? Is there something where why are we in this dispute? Is there anything in writing, contracts, emails that might be relevant to that dispute? Maybe you want to look at those as part of that, right? Additionally, if there is a binding contract, there may very well be some dispute resolution mechanism in that contract, right? The fact whether this dispute needs to happen under New York law or California law may very well guide, maybe I am or am not the right person to work on this dispute, or maybe we need to get someone else within that jurisdiction to help advise as to what the legal and factual aspects of the dispute might be. Same thing if there's an attorney's fee clause, that very often you may take that as perhaps a different input for what the tone of the demand letter might be, right? Very often there's some sort of notice provision. You must inform this person in writing with a copy of email to outside counsel, things like that, right? So make sure that you're looking at these things, and if there is a contract in place, You don't just take the client's word that, hey, yeah, there's a contract, but it's not important. I don't need you to look at it because it's going to run up the bill. Just send a demand letter. That may be what they want. It may not be in their best interest for that to happen. Similarly, for audit provisions, oftentimes, especially like copyright disputes, licensing disputes, if you're going to be requesting an audit, both under contract and under different state laws, there's like very important provisions that need to be complied with in order to, if you end up in court, to make your demand letter binding, right? You don't want to think you're complying with all the things that might be in these contracts, only to file a lawsuit and then, hey, you needed to send a pre-suit letter and your demand letter did not comply with your requirements via contract or state law. Same thing statutorily. You have the DMCA, right? So DMCA, for example, has very there's kind of like a playbook, right? You must have a demand letter that has these 10 magic words in them. Otherwise, it's not really a proper DMCA notice. So there's all sorts of statutes, depending on the nature of the dispute and whether there's any statute it comes under federal or state law. You're going to want to review those statutes to make sure that your demand letter is going to comply with any requirements in order to qualify under that. And lastly, just, what are the time sensitivities, right? This is always a question I ask every client, like, when does this need to be done by and why, right? Everyone needs it done immediately, but is there actually a need for that? And especially now in COVID era where you're not always sending it to the right place the first time, and it may, snake its way through the process saying, hey, I need you to respond to this within 48 hours. If there's really no business need for that, one, it may not be respectful to the other side, but two, is that something that you need to consider within the demand letter? Perhaps if there really is an emergency type basis like that, then maybe a demand letter is not the right route. Right? Maybe you should be going like immediately to seek a preliminary injunction, right? Like things like that. So there's a question here. Often, if a client comes to you for a cease and desist matter, we draft a letter for them and send from in-house. Yeah, so right. So, and this is very common, right? And I'm not saying this isn't something you should not be doing, because the reality is very often, and this will happen, right? Is you'll see like there's a first demand letter sent very nicely from an in-house counsel, or from like the principal of the business, or even just it's an email saying, hey, I noticed this thing. Can you please, do whatever the request of relief is? Very often, I think that's like the appropriate way to proceed, right? And there's reasons for that. Like it's efficient from the business perspective. The business principals are trying to figure out, what's going on here. Hey, let's just send them an email and ask. Very often, that's like the correct way to do it. But I think it, as early and as often as possible that you can link up with whoever's going to ultimately be your litigation counsel. And I think you would still kind of do that, like, hey, CEO of business, like, hey, Bob, what's going on with this trademark license? Like, why aren't you doing the thing you're supposed to be doing? Why aren't you paying the royalty? Why aren't you doing this? You may just want to have that conversation, lined up. So that's all kind of happening along a predetermined timeline. That if this doesn't resolve the dispute, we know what's happening next. And then if something happens in the meantime that you're basically not expecting, like if something comes up, like it's not like, oh crap, what do we do now, right? This is part of that process. We know what happens next, and we're prepared for that. And we're not only just prepared, we're in front of it, and we know what to do. And that ultimately, I think, is going to put you in a better spot from a litigation perspective. Is we know what's coming next, and when we get there, we know exactly how. Like we're prepared for that, right? You're developing a playbook and you're executing it, and there's always going to be surprises. Things are always going to pop up, but that's going to put you in a better place. And yeah, there's another question here. Do you find it helpful to call opposing counsel rather than exchanging letters? Like, absolutely. And I'll get a letter and I'll just like immediately call them and be like, hey, I just got this. Like, can we quickly, speak? If it's something where what the issues are, or you've spoken to the client and discussed them, like, hey, let me just call them, see if we can work this out on phone. That happens all the time, and I think that's a really effective way to handle these things. It's just there's typically not a really fun written record that makes it into our PowerPoint here, but it is a good point, right? That a lot of these things, you're doing things by phone, you're doing things informally, you probably then do want to at some point reduce them to writing to document that we talked by phone, you said you're going to do X, Y, and Z. That should hopefully resolve the dispute. If it doesn't, then here's the next step, right? So I absolutely think that that's a really valid and oftentimes really good way to approach these types of disputes. So getting into the legal aspect here, right? So we're thinking strategically. So again, if aligned with the client goals and cost concerns, right? You don't want to get to trial and be thinking, what is our case? What case law are we relying on? And how does that fit into our series of facts that we have here? You want to front load as much of that as early as possible. That can be done efficiently, and perhaps it's just a run-of-the-mill vanilla trademark dispute, and you know all the major cases in your circuit, and you're ready to go, and it's just like, here's the the Polaroid factors, and we're dropping that in, like, great. But that may not be the case. There may be some unique sets of facts, and I would posit to you that it's really important that you do as much of that as is reasonable under the context to really get a really good demand letter that analyzes all those facts in context of all the relevant law, and it's going to make a really, really, really good demand letter that someone picks this up, they read it, they say, oh, you're right, let me forward it to my outside counsel, what do you think? They read it, I'm like, yeah, that's the case that says that, they're right, you should, so that's ideally what you want to be doing, right? Is you are writing a story, you're drafting a narrative that convinces the recipients of the letter at the business level, at the outside counsel level, that they got us, we better take action, we better comply with what they asked, right? That's what you want. So the way to get there is to do the work, is to review the facts, research the law, draft a compelling narrative, and kind of prepare for that counter argument, right? Okay, well, if they really disagree, what is their possible disagreement? What can we possibly put out there that is going to prepare for that counter argument and is going to win that legal dispute before it even starts? So that is like a really, I think, important aspect here. I think it's going to help you when you start thinking about what this looks like in litigation. It's also just going to like really like kind of frame the case for you and your client. And the flip side might be like you do all that factual and legal research and you put it all in the letter and you go to your client and you say, whoa, you should not be sending this letter. This is you in fact need to, so you can have that conversation too, right? But oftentimes they don't know that, and they need someone to kind of look at the dispute and say, hey, you're doing the wrong thing here. You need to change the way you're doing it. Otherwise, you're going to be in trouble. So, just we kind of predicted some of the stuff here, but outlining all the factual legal elements, consider that tone, right? And we'll get into this in the context of declaratory judgment type considerations. Are you making an explicit cease and desist demand? Are you requiring them to do something? Or is it something short of that? Perhaps there's an initial letter or a phone call or something else. And then on the back end, if that first informal or moderately formal contact doesn't work, then maybe the tone changes. Are you requesting them to perform a certain act? What is I think this ties into the legal research and the factual research is what has happened, what does the law say, and what is the proper remedy in those circumstances, right? Oftentimes I've seen demand letters where it's like, and we want $1 million in attorney's fees. It's like, well, this is a claim that could never possibly have an attorney fee demand attached to it. So why? It's ridiculous, right? Or it really is that, right? It's like, we want you to shut down your business, hand over the domain name, abandon your trademark application, whatever it is, right? You want to know what the outcome of the letter is going to be. What are the legal requirements that they're going to have to do, and show them what they are and document those. And that way you almost have a checklist of when you're resolving this dispute. You get on the phone with opposing counsel, like, okay, you just need to do A, B, C, and D, and we're done here, right? You've already kind of outlined that for them. Getting into that time period, again, kind of thinking sensitively now with everyone not necessarily working from their office or receiving their letter in where they work, so maybe delays, and then warning of consequences of noncompliance, right? If you do not respond to this in 10 days, we will file suit. Just be prepared to do that, right? If you say, if you do not do X, I will do Y, and then you don't do Y, it can kind of blow back on you sometimes. So you want to be prepared in the context of writing the demand letter and of sending it out and preparing it and talking to your client to say, strategically, if this demand letter does not work, this is what we're doing next. And when that time comes to pass, we actually have to do that. And we actually have to have the litigation budget in place to do that, or we have to have litigation counsel. So be thinking about, what happens next if the demand letter does not work. Or if it does work, right? Maybe you're resolving a dispute and you get what you asked for. So again, be considering those second level consequences. So if you draft a demand letter and you say, there's a live controversy here, you need to do this, or cease and desist, or we're going to sue you. The big blowback here, and I'll get a little bit more into the declaratory judgment later, is that they can say, well, there's a real active dispute here. Instead of waiting for you to file suit in the Southern District of New York, we're just going to file suit in California in our home jurisdiction, and we're going to be at the courthouse steps, and we're going to be kind of favored. So you got to be thinking about what is the goal here? Is it to position the dispute for a jurisdiction that you favor because you think this is going to litigation? Then maybe that should be something that plays into your strategy of how you craft the demand letter. Again, if you have a larger portfolio of pending applications, registrations, copyrights, patents, whatever it is, how does this affect the current portfolio? What about that portfolio needs to be expanded or used within the demand letter? Again, cancellation litigation proceeding, like where is this trending? There's all sorts of different defenses, like Communications Decency Act, where there's, if you're doing like defamation type stuff or publicity, DMCA things, there's all sorts of like counter notices, and now you're on a really, if you don't file suit in 14, so there's all sorts of like, if you send this, I'm just sending a form demand letter, and they respond really aggressively, and you're not prepared for that response. Now your client is in the hot seat, right? So that's one of the potential blowbacks of like, I'm just sending a demand letter, not really thinking of the consequences, but my client wants me to send one, so I'm going to send it. And now it's like, hey, you got to be in federal court in 14 days, right? So you got to be thinking that through when you're sending that demand letter throughout. And then the Streisand effect, which I'll get to a little bit later, is a fun one as well. So that's kind of the the outline of, hey, these are all the things you should be considering about. Let's have a little fun here. When can we use creative demand letters? Okay, so here we have Netflix, Stranger Things. Humor can work, right? So again, I don't think all these examples I'm going to show are necessarily useful for every demand letter, and I'm not suggesting that everyone should be like, now we have a room full of IP attorneys that are now going to go out and like stop practicing IP and crafting humorous demand letters. I mean, Bree would probably love that actually, but we have jobs to do, and we're professionals, and this isn't always the way it's going to go. But I think there's lessons that we can extract from these in terms of having a strategic perspective on this, but then also having kind of like a lighthearted, like what is the goal of the letter, and like what's the best way to get there. And not every demand letter is really appropriate and shouldn't be drafted as if you're planning for it to go viral. I think we have all other things to do, but I do think the lessons are interesting, and it's also just fun to read. So look, I don't want you to think I'm a total wasteoid, and I love how much you guys love the show. Just wait until you see season 2. This is a demand letter from Stranger Things to someone that was mimicking the show. But unless I'm living in the upside down, I don't think we can deal with you for this pop-up event. We're not going to go full Dr. Brenner on you, but we ask that you please not extend the pop-up beyond its 6-week run, and reach out to us for for permission if you plan to do something like it again. Right, so this demand letter that Netflix sent got really good, kind of like what did go viral, and people thought it was humorous, and the demand letter itself brought in aspects from the show and did it in a creative way. But we have here just a creative use of that. Another one that was humorous was Bill Murray has a clothing brand, which you can see like a little figure on his pink sweatshirt, and he used some Doobie Brothers music within an advertisement, and this was during COVID, so I think September 2020 this letter was sent. And the Doobie Brothers sent an email, a demand letter, basically saying, you know that we like the song. We agree that you can keep, we know that you like the song because you keep using it in ads for your Zero Hucks Given golf shirts. However, given that you haven't paid to use it, maybe you should change the company to $0 Given. We understand you're running other ads using music from other of our clients, and it seems like the only person who uses our client's music without permission more than you is Donald Trump. This is the part where I'm supposed to cite the United States Copyright Act. I think I actually have it up here, and excoriate you for not complying with some subparagraph that I'm too lazy to look up and threaten you with eternal damnation for doing so. But you already earned that with those Garfield movies, and you already know you can't use music in ads without paying for it. So again, these are two attorneys that seem to be familiar with each other. Kind of like we don't need to have a 10-page demand letter with all the different facts and law. It's like you shouldn't be doing this. Like let's cut it out. Let's jump to the chase here, and it worked, right? Again, the demand letters went viral. The response was also kind of tongue-in-cheek, right? First, I would like to compliment you on finding levity in the law at a time when the world and this country certainly could use a laugh. Your client's demand was able to cut through the noise of the news cycle and remind us how much we all miss live music these days. We would also like to confirm that both our firm and the good folks at William Murray Golf are indeed fans of the Doobie Brothers music, which is why we appreciate your firm's choice of taking it to the streets rather than to the courts, which are already burdened with minute-by-minute real problems, right? So that's kind of one way to handle, right? Rather than just immediately rushing to the courthouse steps or sending a really stern cease and desist letter, which ultimately might achieve the same goal, right? But this is more fun again, right? Just before I get to the next one, does it have an effect on injunctive relief? For example, you want to send a demand letter and client waits a while to seek your TRO. It certainly could. I mean, I think you have to. I think that'd be a really good research question, right? It's hard to kind of answer that in the abstract of, what is the relief that you're seeking? What is the time frame upon which you might need to seek that relief? If you sit on your rights for 2 weeks while you wait for the demand letter to process to play out, are you now, when you do go seek your TRO, is the court going to say, hey, this isn't an emergency anymore because the thing already happened, right? So we're not going to give you a TRO. We're just going to, just get in line, and we'll have a status conference in 4 months. So yeah, I mean, totally, right? That's exactly what I'm saying. Is you need to do the research and say, this is a dispute that if we don't, there's a Netflix pop-up that's going to happen tomorrow, and if we don't get a TRO, then we're the controversy is over. They already did the event and it's done. And I know that there was I had a friend of mine that had a dispute where there was a parody show happening on Broadway, and it was like an off-Broadway show. So, sorry, it wasn't on Broadway, it's off-Broadway, and it was going to happen like the next week, right? So it's like the show's happening, and if you send a demand letter and they don't respond by the 5th day, then that's when the show's happening. And so it's you got to decide, right? It's not always a tough, it's not always an easy question about like what the timing is here, what's the right thing to do. It's a conversation you have to have with the client. You have to, understand the facts. You have to research the law. You have to know, like, if we seek a TRO, that's going to, take this much time and money. It's going to, involve us to do these things on this. But like that might be the right move for someone. But it may also not be. It may be, okay, let's let the demand letters play out, and we'll get there when we get there, kind of thing, right? So it's going to depend on circumstances of that case. Any best practices for filing effective trademark reports with social media platforms? Uh, yeah, I guess it varies by different platform and jurisdiction. I mean, it's not really in the yeah. I mean, I think it's familiarity with the platforms. It's knowing how they like to receive the requests and in what format, and having all the proper registrations in place. I think a lot of the bigger U.S. platforms are better than the ex-U.S. platforms. That's fair to say, or just easier to navigate. And so outside of the U.S., it may just be, hey, let's hire someone locally that knows how that platform handles these requests and knows exactly what they want, and they're going to be able to prepare it quickly, efficiently, right the first time. On a much more client-friendly budget. So that oftentimes that might be the right route. Whereas in the U.S., it may just be, you filled the form, they disagree, and now you got to figure out what to do next, right? So a lot of these demand letters I'm talking about kind of party to party, but you're right. Oftentimes like a DMCA request isn't going to the party, it's going to a platform. And so I think a lot of these principles are going to apply equally to I am contacting a certain platform. What is the strategy behind contacting that platform? What's the best way to approach it? Oftentimes, just complying with exactly what they want is the best way. Oftentimes, that's not enough. Knowing someone at the platform, or knowing someone who knows someone at the platform, or that may be depending on where you're going, a route as well. What's the going rate of another question? Time for business to rebrand. It used to be 6 months. That's far too long. Is it 30 days, 60? I think it's going to depend on the circumstances. I think, I've certainly asked from, basically this, right, if it's something that's really impacting business, then anything short of immediate might not be enough. If it's something that this is a different brand that's not really impacting your business, and they're on the other side of the country or the other side of the world, they have 1,000 units they need to sell off, like, is it really going to kill you if they take 6 months to sell the product? Depends. So again, another, instead of using humor, TripAdvisor, in this demand letter that went viral for unauthorized use of the TripAdvisor name and logo, it wasn't for a humorous aspect, it was to make a statement, right? So TripAdvisor wrote concerning Superfund Happy America's unauthorized use of the TripAdvisor logo for basically a non-LGBTQ friendly use. And so their demand letter went through to say, I'm coming out and saying clearly you are infringing upon our IP rights. Further, your representation that your non-LGBTQ friendly platform is in negotiations with TripAdvisor as a potential sponsor is completely false, right? So the issue here is like TripAdvisor did not want to be associated with these guys. And what's the best way to basically draw attention to the fact that you are not associated with them, and in fact, you are supportive of inclusion, right? So they drafted a really cute demand letter that used a lot of puns that, TripAdvisor trademarks are protected in many countries around the world and over the rainbow, including, right? It was a really fun way, again, that went viral to make a statement that TripAdvisor not only does not support the statements that this rogue company was making, but is in fact, trying to be inclusive, or at least representing in the demand letter that that's how they're going to approach it, and they're going to draw attention to the dispute in a way that is positive to TripAdvisor's brands. So here's just a few of the puns pulled out. When Bree was talking to me about this, I was like, Bree, we gotta throw lots of puns in here. So if you haven't checked it out, I'll plug the marketplace for all the fun punny merch. So Born This Way, I Will Survive, Black Me Out, You Make Me Feel my real disappointment that you might have thought this was an acceptable way to do business. Another question, what's the range you would consider as a reasonable amount of money to pay for rebranding? Again, going to depend on the circumstances, but I would think it should be I always like to start, like when I learned about negotiation, like in an academic setting, like you always want to come from a place of like, there's a ration. Like I'm not just picking a number out. Like you need to give me $1 million. Right? Well, where'd you get $1 million from? Well, it's just I picked a number. Right? Is there a reasonable basis that's tied to the facts in that dispute of like, hey, like I used to represent like a hotel brand, and the people that the hotel company was sending a demand letter to were they owned a hotel and they needed to now debrand the hotel from that flag to a different flag. Well, it's really expensive to get someone to get like one of those trucks, go up there, remove the thing. It probably costs $10,000 to put up. I didn't know that, right? So you may want to do some investigation, like, okay, well, if they're going to rebrand, what's that going to cost? How much time is that going to take? Talk to your client, ask, like, they're probably in the business, right? They probably know, depending on the circumstance. Or you might have experience, like, there's 2,000 units, it's going to cost them this much to destroy them, it's going to cost them this much to take things down. You just, think about what the actual cost is going to be and use that as a starting point. Is that, if it's $10,000 and we're giving them that to rebrand, is that, the right thing? Hey, we know you're going to go out of pocket. What if we offered you this to defray your costs? Is that going to motivate them? Is that going to be more efficient, right, than going to litigation to get that outcome anyways? It's a really good point. So next question, when can demand letters go wrong, right? So there's one here where there's this Richard Trent was a township attorney. He was legal counsel for the town of West Orange, New Jersey, not too far away from where I am in New York, and sent this very strongly worded cease and desist letter to basically a resident of his town because he registered a domain name, westorange.info, and used that domain to provide like factual information to the public about things that were going on in that township. And the township attorney sent this really strong demand letter that basically it's a violation of federally protected rights, going to cause confusion, accordingly cease and desist, and basically you withdraw the domain or something like that, right? So the township attorney did this, and then there was like a town meeting, and the residents showed up, and they're all like, why is the township doing this? We support the resident. This is like, it was the most active township meeting the town ever had in support of the resident being like, hey, this is a ridiculous demand. So I think a really important part of demand letters, and I think also playing into whether you want a demand letter that may be tongue-in-cheek or maybe playful or maybe informal versus really strongly formal, is know your audience, right? Who's sending the demand letter? No, sorry, who's receiving the demand letter? Is it a big business that is going to have an in-house legal department, an outside counsel that's going to be reviewing it? Maybe you want that to be a really well-worded demand letter that has all the facts and law and goes on and on, right? Or is it something more informal where, like the Netflix one, right? There's a community of people that love Netflix and love Stranger Things, and they same with. So I think that's what is a common theme here, right? Is these demand letters is they're knowing who the audience is, they're knowing what's going to connect with them, and they're knowing that the right way to do that is to send something that is positive and thoughtful and strategic, but is going to connect with the audience in a way that's going to support, like the community, the hive mind is going to be like, hey, the person that's sending this mailer is right. Like the person who's doing this is wrong. They should take it down. They should stop doing it. It's going to get your litigation goal more easily complied with, right? And so there's other examples here, and I'm not saying that these companies are necessarily bullies, but I'm saying that in the press they were described as bullying, and in so right, Backcountry had a letter writing campaign where basically any company that was using the word backcountry to describe, I'm using the word describe, but that was using backcountry in their business for ski and winter apparel was getting a demand letter saying you can't use that you can't use backcountry. And so there's a huge pushback on that, and all these different companies are getting these letters, and everyone's like, hey, you got to stop doing that, right? So it's often hard, and if you are a recipient of a letter like that, it can often be hard because you're like, well, the most efficient thing to do is just to comply with the demand and rebrand, maybe it is, maybe it's not. But it may be strategic in how you're thinking about that. And then from the sending perspective, if you're going to start a letter writing campaign and there's people that are, arguably infringing your mark, just kind of reading the room, and maybe that really is the best thing for you to do. But maybe you can be strategic in how you do that and make sure you're doing it in a way where, again, it's going to be a positive experience for the brand. It's going to achieve that goal of getting your company exclusive use of a certain brand over time, right? So again, falling back on what is the strategy of doing that, and then here perhaps you do get some huge blowback, and you're going to change course to comply. Hey Bree, see you popping in.
Hattie. All right. It's time for the very, very last CLE code of Alt Legal Connect 2021. I know it's really sad, but get your paper, write this down. The code is 3. Demand 6. Is that what this is? I can't read it. It's in front of my face.
So it looks like to me. I think you got
3. Demand 6. Okay. All right. Thanks, Moish. Keep going.
All right. Now the Streisand effect. All right. So this is a phrase. I don't know if anyone knows. So Streisand effect is where the act of sending like a demand letter, right, calls more attention to the dispute than if you had just let the dispute kind of carry its own momentum and naturally die out, right? So the way that this, if you don't know the history of it, what actually happened is Barbra Streisand, the famous singer, has a California beachfront property, which you can see here. And there was a photographer who took basically 12,000 photos of the California beachfront to document beach erosion. And one of the photos was just so happened to be of Barbra Streisand's house. And the photographer put it up on his website, and somehow Barbra Streisand saw this and was like, hey, I don't like this photo of my house being out there. I'm going to sue this photographer for a violation of my privacy, so that I can remove this aerial photo of my house so I can, be secure in my celebrity enclave. So the reason we're talking about this, and the reason that this photo is now before you here, like 20 years later, is because the act of filing that lawsuit basically caused notoriety over the visual depiction and location of Barbra Streisand's house, which basically caused the exact opposite reaction of what she wanted strategically, right? Which is to not let people know where she lives. So before she filed the suit, it came out that there were 6 total web views of this picture on the internet site on which it was hosted. And then once the suit was filed, within the next few whatever amount of time, it was 500,000 views, right? So oftentimes the act of litigating over these things, maybe a demand letter isn't the right thing at all. If you send a demand letter, it's going to cause a huge ruckus, and maybe the thing is just going to, whatever this infringement is, will die out on its own volition, or you can just kind of give it a gentle nudge, and it will, so maybe a big lawsuit isn't always the way to go. So the idea being that be thinking about, again, the long-term implications of these demand letters. I'm sorry, this is a little bit out of place. This was the response letter to that westorange.info, where he basically responded really nicely. And at the end, the punchline was kind of, if you manage to produce supporting authority that even remotely passes the lab test, I will donate $100 in your honor to the ACLU. I plan to make the donation online, assuming the state of New Jersey has not shut down aclu-newjersey.org. So, really good response letters is also part of it, right? And helps tee up, right? I think it's both. It's that tennis thing, right? It could be on either side, where you as counsel are going to have the opportunity to weigh in and think strategically about how this demand letter is being crafted and what the tone's going to be. And it's, not that we didn't get the joke, but since Mr. Freibel does not previously encounter a humorous lawyer. He actually thought your letter may have been a serious effort by the township to protect its legitimate interests. Rest assured, I've at least convinced him that it was certainly not some impulsive, ham-fisted attempt to bully a local resident solely because of his well-known political views. After all, as lawyers, you and I both know that would be a flagrantly unconstitutional and would also, in the words of my 4-year-old, make you a big meanie. So, just be thinking about, not every letter's going to go viral, but, think for a second if it does, what it's going to look like. Consider the audience and community. Consider that power dynamic, the tone, time period to respond. It's all going to be contextual, right? Every question I said, well, it depends on the facts. I think it really does. I think how you write a demand letter, what the tone of that demand letter is, time frames, monetary values are all contextual. And they're all contextual with client's values, litigation need, strategic goal going forward. Similar mindset on the reply. Consider the goals and audience of the party that sent it to you. Often that will be, kind of conveyed to you in the demand letter itself. But very often you receive a demand letter and you ask the client, like, hey, what's going on? Is this true? And they say, no, there's all these things that are not even mentioned in the demand letter. Like, how could they even think that this is what? So that's your role, right? It's like, well, the person who sent this demand letter may not have done all the really good diligence things I talked about earlier, and they only know half the story. And so it's your job as the counsel to say, hey, there's huge gaps in here that once you understand those gaps, like the whole thing is going to be reversed. You're going to be on the, so that's your role, right? In a reply is to understand, again, what those facts and law are, to craft that into a really good responsive demand letter aligned with that company's goals and litigation need, and return the volley, so to speak, and frame that up for, perhaps, hey, look, this is going to litigation no matter what we say, but, maybe we have an attorney fee claim. Maybe we have something else. Maybe it's just teeing it up for the litigation, getting our ducks in a row, right? Or maybe you really can just end the dispute there by responding really well with the other side of the story that hasn't been considered. Lastly, declaratory judgment. One more really good letter, and I'll get to declaratory judgment. I know I'm running out of time. So I really like this fan letter. It's a little bit old, but it was from, I'm one of your season ticket holders, tried to attend the game. Basically, they're sailing of paper airplanes that are causing a really big risk of injury. Because you're the Cleveland Browns, I ask that you're in a position to control and terminate these really dangerous paper planes. Otherwise, I'm going to hold you responsible for any resulting injuries. And so the Cleveland Browns response letter was from the general counsel of the Cleveland Browns to the sender of the letter. Attached is a letter that we received on November 19th, 1974. I feel that you should be aware that some a-hole is signing your name to stupid letters, right? So perhaps the CCing Art Odell, just reading the names here, right? So, the idea is, and I did have some additional language where I thought on judgment, which didn't get in, and I'll just read from my other slides. Basically, the declaratory judgment, that's the MedImmune versus Genentech case, which, I don't know if I can, someone can drop that in the chat, like a link to it. But basically, if you create a substantial controversy between parties having adverse legal interests, sufficient immediacy and reality to warrant relief, that's the Supreme Court jurisdictional case, where there's going to be a balancing obligation between placing the party on notice and creating declaratory judgment, basically to create jurisdiction for a DEC action. So a big part of this, I'm sorry I don't have the slides to show you here, is to evaluate the risks of the declaratory judgment action, to recognize that sending a demand letter, if you use certain trigger words like cease and desist, infringement, lawsuit, it may trigger jurisdiction. So the question here is we usually send demand letters prior to filing opposition, saying that if they don't comply, we will likely file opposition to that application. I think I would want to do research on what the declaratory judgment jurisdiction is exactly on that issue. But the idea being, depending on how you word it, you may or may not confer jurisdiction for someone to say, oh, that's cute, you're going to file an opposition. Well, here's a federal district court case in a different jurisdiction that is not in your home jurisdiction. So I'm not saying it is or is not a good idea to, and oftentimes I use demand letters that have language along those lines. But the question would be, is that an outcome that's okay? Is that something we want to consider, or is that something where we just want to use that standard language? What's the risk in that circumstance, or is that part of some negotiation? So again, it's contextual. But I think it's something you should be considering in your strategic goal. Is are we not conferring jurisdiction? Are we being aggressive? Are we not being aggressive in making a concrete legal demand, which we believe needs to be complied with, and what's the rationale for doing that or not? So I'm not saying do or do not do it. I'm saying take a step back, consider the strategic rationale in including or not including that, and then go from there. And then, obviously in a opposition cancellation type proceeding, it would also be considered, timing-wise relative to a pending trademark application or some other trademark portfolio, or it's maybe a larger business dispute, right? Where it may just be a simple opposition cancellation action, and that's, right. So if it's resolved within those bounds of the TTAB by you or the other party, it doesn't really matter. Where if there's some larger litigation, potentially, then maybe it doesn't make sense to go one way or another. So that's kind of my time here, I think, more or less. But if there's any more questions that are coming, I'm happy to answer until Bree kicks me out.
I wouldn't kick you out. I mean, I think the people are enjoying listening to you speak, Moish. Like, what am I going to do? I mean, it's not like you're being a jerk to somebody. If you were being a jerk, I would have to kick you out, because we all know
There is a
from
no church.
3 days of listening to Bree say, don't be a jerk, or I'm going to have to ask you to leave. Don't be a jerk. We all know that I'll kick you out for that. But
I do like that. And our firm also has, we have a very strict, no jerks hiring policy, and we tell all our new hires that, and it seems to work really well. So appreciate your your reminders.
I mean, I feel it every time I say, I'm like, my audience doesn't have any jerks in it. But I don't know. I feel like I'm supposed to say it, so I do. So thanks a ton, Moish, for this. It was incredibly informative and enjoyable. I think we all had a blast. And when you have some time, pop into the chat and just see what everybody was saying. Yeah, tons and tons of thanks, and this was great, and it was incredibly helpful. We have about, let me math for a second, about 7 minutes before closing remarks. So go grab a drink, whatever kind of drink is appropriate for this time. And we will see you back here at 3 o'clock for closing remarks, which will be pretty brief. And then after that, we will have our happy hour. That'll be fun. Happy hour and prize drawing, let me mention. So go take a quick break. I will see you back here at 3 o'clock. Thank you so much, everybody. And thanks, Moish, for this wonderful presentation.
Thank you for having me.